everyone.
I came according to plan. I couldn't come here earlier.
Is there a hardback too?
Our upcoming panel now is going to be addressing the use of force and targeting. The panel is going to be moderated by our very own Professor Scott Silliman, who many of you certainly know as a sought-out expert in national security law and military law. Joined the faculty of Duke Law as a professor of the practice of law in 1993, following a 25-year career as a Judge Advocate General in the United States Air Force, retiring as colonel. Among his many military accomplishments, he headed the deployment of all military Air Force attorneys and legal personnel during the Gulf War. Has also held major legal positions at Air Combat Command, which is the largest constituent force within the United States Air Force, and teaches national security law at 3 law schools in this state. We very much appreciate Professor Silliman's moderation, and without further ado.
Thank you, David. The short version of that is I served in the military and I teach. I think all of us know that throughout the centuries, the law of armed conflict, law of war, whatever we want to call it, and particularly that aspect of the law of armed conflict, the jus in bello, has evolved. And that's particularly true since the Second World War. We've had to wrestle with questions defining a target, whether that be an individual or a facility, whether it's a dual-use facility, whether it's a legitimate target or not. We've had to wrestle with questions about who is entitled to use lethal force, who is entitled to what we call the combatant's privilege under international law. And further, a great deal of work has gone into minimizing what we call collateral damage in precision targeting. And that's very obvious from what you've been reading lately about the criticism of airstrikes in Afghanistan of late and the restrictions that have been imposed by senior military leadership in that conflict. Now, these types of issues have traditionally been analyzed through the prism of interstate conflict. You've already heard references this morning to Geneva Conventions. I would add that you have additional guidance in what we call in 1977 additional protocols to the Geneva Convention 1 and 2, Protocol 1 governing interstate conflict, Protocol 2 governing non-interstate conflict. And we need to know, first of all, that the United States is not a signatory to Additional Protocol 1. We recognize some of its provisions as customary international law, but not all of them. And I think, I don't know whether Mike's going to speak about this, but one of the particular provisions of objection to the United States is what we call Article 44, which actually indicates that rather than a combatant having to distinguish himself from a civilian at all times, Article 44 of Additional Protocol 1 requires that only when one is preparing for or actually engaged in military operations. And the United States, I believe, objected to that simply because it tends to legitimize exactly the type of individual that we're dealing with now with regard to terrorist threats. Who is al-Qaeda? Is al-Qaeda an armed force? Are members of al-Qaeda civilians taking direct part in hostilities, which is the key under the law of armed conflict? Or are they something else? And on the other hand, rather than talking about who can be the victim or a lawful target of military force, what about those who can use military force? Clearly, international law that we've been talking about already this morning authorizes a member of the military forces to use lethal force. What about a military contractor? What about someone who is employed by what used to be called Blackwater, now XE? And further, the intriguing question of what about the CIA conducting targeted killings? Is a CIA officer entitled to the combatant privilege? Now, these are difficult questions. Alex's panel suggested that if there is some rubric of international law that gives us clarity on detention, there is nothing with regard to targeted killings and the use of force. And so I'm going to invite our expert panel that's been gathered this morning to take on some of these tough issues. And their bios are in your materials. I invite you to look at them and scan their impressive credentials, but let me just mention a few things now. John Bellinger, of course, is a partner at Arnold & Porter, has served our country significantly in government positions, most recently as the legal advisor to the State Department and the Secretary of State under Condoleezza Rice, and before that, he was the senior associate counsel to the President and legal advisor to the National Security Council. Has served significantly and was in a very real sense, many of the discussions and the decisions that were made of the last 6 or 7 years. Eyal Benvenisti, is the Annie and Paul Yanowitz Professor of Human Rights on the law faculty of Tel Aviv University. And prior to that, he was a law professor at Hebrew University and the director of the Minerva Center of Human Rights for Human Rights. He's widely published. He's been a visiting professor in many law schools within this country and also abroad. Impressive scholar in this area. The last panelist who will be speaking is Mike Newton. Mike's a professor of the practice of law at Vanderbilt, and he's an expert in what those of us who used to wear the uniform call operational law, the very subject of this panel. Prior to joining the faculty, Mike had a distinguished Army career as a judge advocate with many prestigious assignments, including serving in the Office of War Crimes Issues at the State Department. And I should make a last note, and I'm not trying to sell you a book, but Mike and Mike Scharf, over there, who's on this afternoon's panel, are the co-authors of the book Enemy of the State, the Trial and Execution of Saddam Hussein. Seems like history now, doesn't it?
I'd like to sell it.
All right, what we are going to do with this panel is to try to probe the perimeters of what law, if any, governs the use of force against terrorists, and particularly this whole question of targeted killings. So I'm going to invite each of the speakers to give their comments over 15 to 18 minutes. I very much want to reserve time at the end of this panel for questions, particularly from you in the audience. So our first speaker, John, let me invite you to start our discussion.
Great. Thanks, Scott. And it's nice to be back to Duke again. I was here a number of years ago to open the new Center for International and Comparative Law, and again last year. It's great to be back, and I thank the organizers for putting together this panel. I'm going to start my remarks by putting this discussion in a little bit of a policy context, since I am the person most recently out of government. So I'm going to focus my first set of remarks on what has changed in the last year under the Obama administration and what hasn't changed. And then I'm going to focus, with that policy context, more specifically on the issues for this panel about use of force, where and against whom. So let me start. It's, of course, appropriate that we are speaking today. This is one of the reasons that the organizers picked today, because 1 year ago today, President Obama issued his famous 3 executive orders that made many changes from the Bush administration's policies. 1 year ago on January 22nd. Those 3, as you know, were 1, to close Guantanamo within 1 year and review everybody who was there to determine what ought to be done with them. 2, to end the CIA interrogation program, but to conduct a review of what sort of interrogation program there ought to be. And then finally, and perhaps most significantly, and perhaps even the hardest, was a review of all detainee laws and policies to determine what should the legal framework be, what should the policy framework be. I applauded those executive orders at the time, and think that they were good decisions. Several of us on these panels worked actually quite hard during the Bush administration to achieve the results in those executive orders, and it was disappointing that they couldn't be done sooner. So as a policy matter, I actually agree with what was done, and they did reflect some change. That said, as I think all of you know, since that day a year ago, actually relatively little has happened, even with respect to those 3 executive orders. 1, obviously Guantanamo has not closed, and It looks like it will not close in 2010, and it may not close during the first term of the Obama administration presidency because the Congress has blocked the ability of the president to move people to the United States. The CIA program was shut down, but of course it had really been stopped years ago. And so and in fact, as you may have seen in papers just a couple of days ago when the Director of National Intelligence was testifying, he is already bickering with the Director of the FBI about who ought to be doing interrogations and should the intelligence community be doing more robust interrogations. And then finally, the third executive order task force, which was to review detention policy overall, missed its 6-month deadline, extended to a year, should have reported by now, and has not, in large part because the issues are so difficult. Now, so those are the things that have changed. What I'd like to focus on for a few minutes is what actually hasn't changed, and that's really the remarkable thing, is that there has been, in fact, more continuity than change. The main point is that the legal framework that the administration is applying in fact, continues to be a law of war framework. The president dropped, and I think this was a good idea, the label of a global war on terror, which I think for a number of reasons did more harm than good. But he is in fact still pursuing, as a legal matter, a global war on terror. And most significantly, he is applying the laws of war for detention and for targeting. He, in his famous archive speech, emphasized we are at war with al-Qaeda, and then, as Matt Waxman mentioned, under sort of unfortunate pressure from Republicans recently, has had to keep saying, I recognize that we're at war, I recognize that we are at war. What that has meant is that he continues to use the laws of war by our military and our CIA to kill terrorists around the world. He uses it to detain people, to detain them indefinitely without trial under the laws of war, and to assert the right to detain people even though they have not been charged with any crime. Furthermore, he has emphasized that it's not the criminal laws that apply, but it is the laws of armed conflict, and he has asserted a right to detain people not just in Afghanistan, where there are active hostilities going on, but essentially anywhere in the world, and I'm going to talk about that in a moment. With respect to the prosecutions of those individuals who he is detaining who can be tried, and again, he's not saying that he will try everybody, but for those who can be tried, that he will try many of them in military commissions. He has said, as you know, that he will try the 9/11 planners in federal court in New York. I personally think that that's a good idea. Those people had, in fact, clearly committed federal crimes. But to the great consternation of many of the president's supporters who thought that he was going to immediately jettison the military commissions, and of course Professor Silliman, as an expert in this, has testified, he has said that he is going to retain them. Largely because I think he has found, and I'm personally not a particular fan of the military commissions, but I think he's found that many of the people who have been detained cannot be tried in federal court, not because of any way that they've been treated, but because they did not violate our federal criminal laws. The things that they had done, to the extent they were wrong, were violations of the laws of war. So detaining and targeting people under the laws of war, prosecuting people under the laws of war, he has continued in a lesser-known announcement last summer, has announced that he is going to continue the practice of renditions. Now, not just even the renditions that had historically been practiced back through the Bush and the Clinton administrations for many, many years, of going out and snatching terrorist suspects and bringing them back to the United States for trial. But if you read the announcement that was made last July, he said, we'll also reserve the right to snatch an individual and transfer them from one country to another country. That's a controversial concept and something that I think our allies will raise questions about. And then finally, with respect to process, he is not giving detainees really more process. As many of you know, the individuals who are being held in Bagram have challenged their detention and have insisted on a right to habeas in U.S. courts, even though they have never been in the United States and are not in Guantanamo. Judge Bates of the D.C. District Court granted habeas rights to a limited number of non-Afghan nationals. That case was just argued on appeal before the D.C. Circuit, and the point here is that the Obama administration is opposing any more habeas rights for anybody outside of Guantanamo. So my point overall is that the legal framework of fighting al-Qaeda and the Taliban that the Obama administration has applying continues to be under the laws of war. And let me comment here briefly. I don't think the student who asked the question was here, who suggests, well, really, or don't the problems of the laws of war suggest that we ought to just be applying a different framework altogether? And I think the Obama administration has found that to fight al-Qaeda, particularly with hundreds of thousands of our troops around the world, one simply can't apply a human rights law or criminal law framework. And think of yourself for a moment, as I know your professors ask you to do, not as a student here, but you are now the counsel to the president, or you are the attorney general, and you have hundreds of thousands of troops around the world who are killing or who are detaining members of al-Qaeda. And the president says to you, you know, I'm concerned about holding these people for a very long period of time. Do you say to the president, Mr. President, my argument to you as a lawyer is you may only detain these people if you try them, and that the military really are out there only as a police force, that they can only detain someone if they can try them for a crime. I don't know, think about whether you would say that as the Attorney General or the Counsel of the President. And I think the Obama administration has determined that they can't accept that paradigm, that they're continuing to apply the laws of war. What are the implications of this around the world? I began, as the legal advisor, a dialogue with our allies to try to do a better job of explaining what it was that we were doing, because our allies obviously felt that many, many mistakes were being made. The Obama administration is going to have to now continue this dialogue. There's going to be a honeymoon for a period of time in which the allies were very happy with these initial executive orders and the direction that the administration is going. But as the administration continues a number of these essentially reviled policies of indefinite detention without trial, of renditions, of military commissions, our allies will then have one of several choices. They can either just sort of hold their noses and look the other way because they like the new administration. They can say, gee, these are the same policies that we didn't like before, and get back into essentially a headbutting with the administration, which was going on before. Or, and this is what I frankly hope will happen, is that they will, seeing that an administration that they like is actually continuing policies that they don't like, there must be some reason for that. And so to continue in a really serious basis a dialogue on these issues. Why are you having military commissions? We've been told by the New York Times that military commissions, in fact, are unfair kangaroo trials. So explain them to us. And that sort of dialogue is really going to have to happen. I think this first year there has been a bit of a honeymoon, but as these policies continue, for the State Department at least, for my successor, Harold Koh of the Yale Law School, they're really going to have to work hard on trying to explain the continuation of these policies. Let me spend my remaining time boring into the details of this panel, which are the rules applicable to the use of force and to targeting. So two issues. One, where can you use force? And second issue, against whom can you use force? Both of these were issues that were extremely difficult for the last administration, and the new administration is going to have an equally difficult time. First, where can one use force? If we are, in fact, applying military force around the world, can it only be, as some of our allies have suggested, can it only be in Afghanistan? Because that's really only where an armed conflict is going on. Well, the position of the last administration, and continues to be the policy of this administration, is yes, there are active hostilities going on in Afghanistan, but is al-Qaeda containing its operations to Afghanistan? Obviously not. So therefore, both the last administration and the Obama administration are saying we have the right to use force in self-defense. That is the key hook under international law, to use force in self-defense anywhere in the world where we are threatened or being attacked by al-Qaeda. So essentially, the Obama administration is continuing as a legal matter the idea of a global war on terror. Now, I found in my discussions, particularly with Europeans, this is an extremely upsetting concept, that the United States is asserting the legal right under international law essentially to use force anywhere in the world. Does that mean you can use that you're at war with al-Qaeda in London and you can shoot people on the streets of London? Well, actually not, because we have two competing international law principles. We have the right of the United States reflected in the UN Charter and under customary international law to use force anywhere to defend itself. But then we have the countervailing right of every other country in the world of its sovereignty to be free from the use of force by the United States. Under the UN Charter, the United States cannot use force against another country. Now, what that's left is essentially a start of the right of the United States to use force essentially in 194 countries where it might be threatened, but then immediately subtracting from that the 190 or so countries who can contain the problem on their own, that they can deal with it. So what the theory at least has been of the United States has been that we have a right to use force against al-Qaeda only in those places where a country is unable or unwilling to contain the threat itself, which really results in just a couple of countries in the world. Afghanistan, Pakistan has given us their consent, although publicly they state that they have not, and then other places like Yemen or Somalia. But this continues actually to be a controversial idea of where can we use force in the world, and it's going to require some further discussion. Now, if that's not difficult enough, the really difficult one was the one that was touched on by the panel this morning, is who can you use force against specifically? Since we're really not attacking these countries, we're attacking members of al-Qaeda or the Taliban in these countries. And the difficult thing there is to figure out who and under what set of rules can one use force against, either lethal force or detention, which is, of course, a subset of the use of lethal force. In a traditional armed conflict, it's pretty easy. People wear uniforms. You know that they're part of an enemy army. Here, maybe a little easier. The person without the uniform who is coming at you with a gun or who is setting a bomb, they would seem to be a combatant. But what about the person who made the gun or made the bomb, or delivered the gun or delivered the bomb, or financed the gun or financed the bomb, or had the safe house? As you get more and more attenuated, it gets to be quite difficult. That's the core of the issue for this panel, is when non-state actors are not representing an individual country, which ones actually can be treated as combatants for targeting or for detention. They are essentially all civilians, but at the same time, they are civilians who are engaging in combat. Now, human rights groups have tended to suggest that they don't believe that the law of war framework can be used in a conflict with a group of civilians like members of al-Qaeda, that the whole law of war framework really just doesn't apply at all. Now, as Matt mentioned, I think over the last 8 years it has become gradually more accepted that one can be in a state of armed conflict with a non-state actor, that even though that's not traditionally the kinds of wars that we have, now that we see groups like al-Qaeda that can assert force on the magnitude that a country can, that the framework of having an armed conflict against a non-state actor is an acceptable one. But it still doesn't tell you what are the rules to apply as far as specifically who can be targeted. Neither the Third Geneva Convention or the Fourth Geneva Convention, or as Derek mentioned, certainly not Common Article 3, tells you specifically who can be targeted. That has left us then with a number of possible legal theories that Derek mentioned. But as you know, the United States is often told you need to comply with international law, and that the law is clear. But as all of you all as lawyers or budding lawyers, law is something that ought to be reasonably clear if you're applying it. And yet 8 years in, it's still not clear to the United States or any other country what the legal rules are for targeting and detention. The International Committee on the Red Cross, and you'll be hearing from the legal advisor for the Washington delegation, Jamie Williamson, who I've spent a lot of time with over the last few years, took this task on about 6 years ago to put together a study on combatancy. It's called the Study on Direct Participation in Hostilities, after the international legal rule that the only time that civilians can be targeted, since normally they may not be targeted, is if they are directly participating in hostilities. But even then, when is a civilian directly participating in hostilities? If they are shooting or bombing by day, but by night they go back home to their house, can they only be targeted when they are doing the bad things while at home they cannot be? The ICRC spent 6 years studying this issue, issued a report last summer, some guidelines, which are not binding on anybody but reflect some guidance. The United States and most other countries agree with some parts of it, but not other parts of it. But I would posit to you that if it took the best experts in the world 6 years to put this together as to who is directly participating in hostilities, the rules are still really not very clear. That has left us inside our country to our courts to try to sort this out. And there have been a number of decisions over the last couple of years, and in fact in the last year, to clarify who is a combatant who can be detained. Judge Bates in the D.C. District Court earlier this year concluded that it is permissible under U.S. law, the Authorization to Use Military Force Act, and international law, to detain individuals who are members or part of al-Qaeda and the Taliban, but not those who are substantially supporting al-Qaeda or the Taliban. Now, just 10 days ago, the D.C. Circuit, in a rather surprising opinion alluded to earlier, the Bahani case, rejected that and said, it was actually not looking at that case in particular, but the theory overall, and said, no, people can be detained if they are members or part of al-Qaeda or the Taliban, or if they are substantially supporting them. And in what was perhaps the most significant part of the ruling, said, and international law has nothing to do with this, that the only thing that we will look to in determining who can be detained is U.S. domestic law. International law is really not relevant. Now, that is going to have to be resolved by our Supreme Court, which probably in a year or two will issue what will be the fourth in this great series of detention decisions to clarify specifically who can be detained. My bottom line on all of this is we are regularly told there is not any problem with the law or gaps in the law. The problem is only a question of implementation, implying that if we would just, all of us, just do a better job of applying the law, it would all be very easy. I think the answer, and I think hopefully you are, by the discussions today, beginning to realize this is not an easy area. There are not clear rules. It's very difficult to accuse someone of violating the law. One can appropriately say that there have been a number of bad policies, and I don't think we're there yet in terms of policy, but we are going to be debating for a very long time what some of these rules ought to be.
Thanks, John. Eyal?
Yes. Yes, I'm going to continue this attempt to address the challenges of regulating asymmetric warfare. And what I'm going to try to emphasize is the link between asymmetric warfare and technological innovations. I think technological innovations are part of the problem because they contribute to the persistency and the prevalency of asymmetric warfare. They empower both the powerful side and the relatively weaker side. But technological innovation is also part of the solution, or part of the beginning of the solution, because they provide new mechanisms to regulate asymmetric warfare. So I'm going to start with a brief synopsis, 3 points. First of all, with respect to asymmetric warfare, I want to start by saying that international law has relied on state consent and on reciprocity to develop and enforce norms to regulate symmetric warfare. And asymmetric warfare, in particular in the fight against non-state actors, poses challenges to this type of regulation because of lack of consent and lack of reciprocity. So this is my first point. The second point is that innovations in information technology enable new modalities of enforcement based on third parties like courts or commissions, and these third parties, together with civil society, develop new law inspired by the growing ability of the powerful side to control the fate of the population subject to its control. And this new law recognizes, I think, three main norms. First of all, an obligation to protect enemy civilians. B, an obligation to explore least aggressive means before an attack or in lieu of an attack. And three, an obligation to inquire after ex post about the lawfulness of the attack. The third point would be that these innovations, the information technology, do not resolve the main problem, which is how to assess the lawfulness of an attack, the excessiveness of the collateral damage. So ultimately, we are left with a problem that I would say the following: that the information that we have exposes the fact that law cannot give us answers to very difficult questions. So first, let me move first to the challenges of asymmetric warfare, and I want to mention four such challenges. The first one is normative. The norms themselves, I would suggest, are not sensitive to the power relations between the adversaries. The laws of war are inherently in favor of the stronger party, the one that is capable of striking the military assets of the weaker party, while the weaker side is unable to reciprocate in kind. Recall that the powerful side can be the aggressor. The weaker party, even the one who fights for what it regards as a just cause, is expected, if it plays by the rules, to surrender. So the burden of obeying the law rests on the shoulders of the weaker side. Moreover, the technologically advanced adversary will most likely refuse to outlaw the new weapon that it has exclusively. The new weapon is usually hailed as more accurate and more humane. And obviously, it gives advantage to the one who has exclusive use of it. And as a result, what Julius Stone observed in 1955 is still very much true today, and I quote, "States only come to a common view on regulating or prohibiting new weapons when no one of them can rely on obtaining or maintaining the lead in their use." So this is the first normative challenge that asymmetric warfare provides. The second one that is posed is the breakdown of reciprocity as the institution that enforces compliance with the law. In asymmetric situations, both sides have strong incentives to violate the law. The only way for the weaker party to harm the powerful is by perfidy or by targeting non-combatants. At the same time, the stronger is not worried about retaliation. The temptation to strike hard and fast to end the conflict swiftly is high. The democratic pressure to avoid casualties at all costs also plays out. So using different arguments, stronger armies have often asserted that the laws of war were inapplicable in asymmetric situations, whether in the colonial context, in so-called low-intensity conflicts, or in the current global war on terror, which is against non-state parties who are not parties to international conventions. The third challenge to the traditional law is posed by asymmetric warfare fought against non-state actors who fight from within urban centers or otherwise abuse the protection that law grants civilians. The traditional premise of the law was that it was possible to isolate with sufficient clarity military from civilian targets, that there were tangible military gains to the battle, such as hitting army bases or gaining control over territory. This premise gave rise to the conception that military conflicts could be compatible with humanitarian ideals, that war could be about inducing concession from the defeating party by degrading its military capabilities, weakening and disabling its fighters without necessarily killing them. But this is no longer true when regular armies fight irregulars. In the asymmetric context, there are very few purely military targets. This dramatically limits the ability of the regular army to identify arenas where it can legitimately project its power. Moreover, it has become increasingly unclear what can be considered as a military gain, especially since control over enemy resources and territory often proves to be a liability rather than an asset. It is becoming difficult to reconcile this type of warfare with a vision of a war fought against an abstract enemy in the quest of envisioned by the 1868 St. Petersburg Declaration of, and I quote, disabling the greatest possible number of men, rather than killing those who are in the target list. And finally, as we just heard, technological innovations allow powerful states to resort to low-intensity warfare without boots on the ground, without missiles or heavy bombardments, but this, and without recognizing that the threshold of an armed conflict has been passed. So is it a conflict that is subject to the laws of war? Another question. So we see that the persistence and prevalence of asymmetric conflict can no longer be disregarded by international law. I would suggest that the inadequacies of the traditional norms and institutions of the law on armed conflict, which were designed to address a totally different logic of combat, need to be supplanted by a new approach that takes relative power among the adversaries into account. Asymmetric warfare is not like symmetric war. It is a very different beast and should be regulated by different norms and different institutions. So this is the second point, how technology could assist in regulating this new type of law, a new type of war, sorry. Fortunately for law and for morality, I would say, technological innovations provide stronger parties with possibilities to make their weapons more discerning and more effective. But why should they invest in more accurate weapons? One reason beside morality is the rise of information technology. Information technology brings the details of faraway conflicts into the homes of people around the world. Public opinion presses governments to react. We thus see a new logic of enforcement emerging, broader, pluralistic dynamics, instead of the dyadic reciprocal relation between the parties to the symmetric conflict. These dynamics involve several actors, third parties like foreign governments, international organizations, humanitarian NGOs, and civil society, global civil society, who have been translating their growing sensitivity to global crisis of human suffering to the promotion of new norms that do not depend on state consent, and new types of third-party retaliatory mechanisms ranging from divestments to criminal prosecutions of those who they find to have violated the law. Let me begin with the new institutions that enforce the law. These include international courts, foreign national courts, international organizations like the UN, foreign governments. There are countries who cannot resist, cannot be insensitive to these pressures. NGOs mobilize public opinion to put pressure on their governments to agree on the prohibition of certain weapons like anti-personnel mines or cluster bombs. These pressures put political and economic pressure on the stronger party in a specific conflict. So stronger parties that fight against non-state actors have now new incentives not based on dyadic reciprocity to eliminate excessive harm to non-combatants. unless they manage to block access to the media, increasingly a difficult task. So freed from the shackles of dyadic reciprocity, we can now realize that not only the modalities of enforcement have changed, the law itself can change and take into account the power disparities between the parties without the agreement of the parties. To take one example, the ICTY has, in but a few years of judging war crimes in the former Yugoslavia, virtually rewritten the law on internal armed conflicts, thereby overcoming years of government's resistance to regulate the way they fought insurgents. So what are the contours of this new law? I would suggest that the new law regards the stronger party as responsible to protect the population in the theater of operation from harm, because it has effective, if only virtual, over the population. In fact, its authority could be regarded as not much different than the authority of an occupying power. Maybe we can call it a virtual occupier. This point requires explanation. In symmetric warfare, the attacker's power does not amount to an ability to control the lives of the enemy's population fully. The defending government is still in control and is, in fact, forcefully resisting the attacker's effort to gain exclusivity. Lacking such exclusive control, there is no basis to impose on the attacking army a positive obligation to ensure enemy civilians' lives, protecting them, for example, from internal ethnic conflicts. Their army, which is still in control, has the duty to ensure their rights. Instead, before and during the attack, the attacking army owes a duty to respect enemy civilians' lives, consisting of the duty to avoid unnecessary harm. In contrast, the same army will assume the duty to ensure the rights of enemy civilians when they become subject to its effective control as prisoners of war, as protected persons in occupied territories. An obligation to ensure the civilians' right is fundamentally different from the obligation to respect them, applicable to parties in symmetric conflicts. The vertical power relations that exist in asymmetric conflicts, particularly against non-state actors, calls for recognizing positive duties towards those civilians like in an occupation, a duty that will reflect the nature and the scope of the power of the attacking army has over the attacked population. Simply put, the more relative power one has, the more obligation it has towards the enemy civilians. Very briefly, I would say that the obligation to protect is quite demanding and calls for three specific obligations. First, the requirement to consider alternative to military action. It asks not only when the targets were legitimate military targets, but also whether the decision to use force against them rather than explore the non-forcible or less forcible alternative was justified under the circumstances. In fact, it implies injecting jus ad bellum consideration, or you might look at it as human rights law requirements, into jus in bello analysis. Second, if there were no available alternatives, the army would be expected to invest resources to minimize harm to civilians. And finally, the army must conduct transparent and accountable investigation after the fact, and maybe also take part in third-party initiated impartial investigations. But does this new normative approach defined and enforced by these new institutions offer a legal alternative that is viable and morally acceptable? The difficulty lies in the fact that whatever information the third party may have, it still needs to be assessed and evaluated. Judgment calls have to be made. Moreover, there may actually be too much information for the law to digest. There are no technological ways to overcome the subjectivity of the decision maker. This fundamental problem was candidly acknowledged by the committee established in 2000 to review the NATO bombing campaign against the former Yugoslavia, referring to the requirement to expose non-combatants, not to expose non-combatants to excessive harm. The committee famously asked questions like, What are the relative values to be assigned to military advantage? What are the standards of measurement in times of space, and to what extent a military commander obligated to expose his own forces to danger in order to limit civilian casualties? And it continued, there are no simple answers. The answer may differ depending on the backgrounds and the values of the decision maker. And they suggested that the values must be of the reasonable military commander. If you know one, let me know. Let me know. So the weighing of alternative, because we all think of ourselves as reasonable, of course, and the question is how to evaluate and review decisions, and who will be the one that would be reliably regarded as reasonable. So the weighing of alternatives to a military strike is very problematic because it requires the decision maker to engage in counterfactuals. What would have been the case instead of striking that person in the crowd? The attackers would have waited for a day or two for the person to appear in less densely populated area. How do you measure that? The availability of information raises still another, perhaps the most difficult challenge for decision makers. With the growing sophistication of weaponry and the accurate information available to their operators, they may now may have too much control to wield and too much information to assess. Operators of UAV predators that hover above Pakistan, as we speak now, as they do 24/7, can now see or sense their target sitting in his living room. The operators know his identity, or at least think they know it, but they can see that the person is sitting there together with his family members. Computer programs can help them accurately foresee how many of them will be killed together with a targeted person. The drone operators virtually control the fates of those people. What legal or moral guidance can one give to the operator who is asking whether to go ahead and kill? Without ex-ante determination of legality, the operator is exposed to the risk of partial and inaccurate review of his or her judgment call. How this judgment will be considered in potential disciplinary or criminal proceedings. These are difficult choices to make, and these choices will be affected by the decider's viewpoint, whether they are the powerful attacker, the weaker defender, or uninvolved third parties. The answer is very much in the eye of the beholder. Given the concern that such assessments are in the eye of the beholder, the likelihood that the decision maker's determination would be accepted as just by the relative stakeholders is not high. The requirements of the rule of law that the law coherently informs and constrains behavior are therefore not met. So I would conclude with a maybe pessimistic conclusion that the advances in information technology expose not only excesses of asymmetric conflict, but also the inherent limits of the law that seeks to regulate them. Thank you.
Thank you, Eyal. Mike?
Well, I want to, as my very, very first comment, thank the organizers. Our experience with the Duke students has been very, very fine, both in the side questions and the organization and the faculty that have supervised them. We thank you all greatly for your time. At the risk of watching Jamie Blanche, I want to get close to one of the ICRC sacred cows and tip it a little bit. In the sense that, that's okay. In the sense that for those who are students here, I think one of the greatest things that you can do in a practice in the field, the Obama administration has found this out, is that the practice of this field is not an esoteric, theoretical, academic, let's think about it. It's a very practical, concrete, real-world exercise, particularly when lives and treasure are on the line, and particularly as an extended matter, when it's our obligation as a free democracy to uphold and support and defend the fundamental human rights values around the world. So these are not light, airy topics, and I think it's important for us to very concretely focus on the pragmatics of application and try to find some real resolution rather than simply allowing the larger debates to be, well, that's really hard, so we'll avoid that issue by the application of another regime. And it's to that end that I want to take on the law of reprisals this morning, which is what the students asked me to do. And I want to posit for you a framework that I think actually helps us as a precise matter. The law of reprisals, any first-year law student can tell you, anybody who's ever had more than 5 minutes of IHL discussion, laws and customs of war never allow reprisals, period, full stop. Well, yeah, but that's also not very helpful in addressing the real problems that we want to address today. I also want to pick up on Scott's earlier reference because I think it's directly relevant, and it's one way of addressing that tension of who are permissible participants in the conduct of hostilities. The law of reprisals helps us to avoid those real hard discussions, which doesn't do anybody any good. And so I would sort of want to focus on the legal regime and propose what I think are some useful observations as to why, in fact, we need to have a concerted effort to address these things. The law of reprisals, very simply stated, reprisals against the persons and objects protected by this part are prohibited, period. Article 20 of Protocol 1. That's then extended in Protocol 1 to civilian objects, civilian property. It's, of course, extended in a very concrete way. My premise, basically, is that the bright line rule, the normative bright line rule, actually obscures the real issues in the fabric of analysis that we want to get to. So I want to unpack that a little bit and help us to focus on the precise issues that we do want to get to. Point one, against the backdrop, is to recognize, as has been stated, but we need to start there, that after 9/11, particularly, the international acceptance that the rubric of the laws and customs of war can, in fact, and should be applied to the ongoing, dare I say, to be politically correct, difficulties with non-state actors, transnational non-state actors. And that's actually an important start point. Because what it says is we really have to come to grips with the questions. And so therefore it's important to us to establish the known benchmarks and then to look for the interstices, the gaps, where we have to address these remaining questions. So what are the known benchmarks? Extrajudicial executions. Under the law of human rights, when can you engage in extrajudicial executions? Never. Duh. That's why we have the whole law of human rights. Under the rubric of the laws and customs of war, when do we intentionally target civilians? Never. It's one of those bright line, fundamental, non-derogable norms. We just don't do that. Similarly, under the laws and customs of war, when do we intentionally enter attacks in the knowledge that such attack, even when it's a lawful attack using lawful mechanisms against a lawful target, when do we ever intentionally, no responsible military commander, or I would dare say policymaker, civilian policymaker in the world would intentionally initiate such an attack in circumstances, in the knowledge, the clear knowledge, that as the ICC elements say, and the ICC crime, and the knowledge that such attack will cause damage to civilian lives and civilian property that clearly are excessive in relation to the concrete and direct overall military advantage. We just don't do that as responsible practitioners. Otherwise, we are directly counseling violations of the laws and customs of war. Here, President, go commit a war crime. We don't do that. What we do, though, by simply recognizing the shibboleth of reprisals or the prohibition on reprisals is we obscure the real questions. And so I want to unpack that. There's also a second predicate point that I think is really important to remember. Anybody who's ever studied the laws and customs of war recognizes the truism of what was said by one of the Nuremberg prosecutors. He wasn't talking about me, of course. He says the law of war owes more to Darwin than it does to Newton. There's an evolutionary process, the aggregation, the response of law in relation to the concrete gaps, the lacuna. That's how law develops, particularly international law, where states come together, as they have after 9/11, I would dare say, to say, here's a fundamental problem that affects us all. We either need a legal regime to address it, or we are simply willing to allow it to be addressed by the cacophony of state practice. I would submit to you that in the context of the questions about who can be targeted and under what circumstances they can be targeted, when they're a non-state actor, that is precisely the kind of problem that the international legal regime should address and that is at present imperfectly addressed, either by human rights law or the laws and customs of war. Because as we've discovered, there are bright line rules that don't fully, completely, accurately address what we need to address, and nor do they really serve justice for us as lawyers who walk into the room to brief policymakers. It is our job to fully explain the advantages, the disadvantages of various courses of action to those policymakers. A simple response that says, well, we can't assess the advantages and disadvantages of various policies because we don't really know what the law is, in my mind, is really an unsatisfactory answer. So to this end, in terms of reprisals, understand that the class of protected persons protected from reprisals is one of those key benchmarks by which the laws and customs of war evolved. When can you have reprisals against prisoners of war? No, never. 1929 conventions and 1949 conventions, it's right there as a matter built into the third convention. Easy. When can you have reprisals against civilian population, the protected persons category defined under the 1949 conventions? Never. Article 33 and 34 are plain about that. When you are in the category of an international armed conflict to which a civilian population falls into the category of protected persons, they're not subject to reprisals. Sick and wounded, same prohibitions. Very clear. But that's old law. And I would dare say that's easy law. That's exactly the kind of people that we want to protect and that are protected. To advocate reprisals against those categories would simply be to overturn, for no good reason, 200 years of legal development in this field. The extension of those basic, and let me just digress for just a second to say why is that. There's some great ICRC review article a few years ago written by one of the participants in the 1977 negotiations, trying to explain this extension in the protocol of these very bedrock concepts, says that it's necessary to prevent appalling atrocities. He's right about that. There's a long history of reprisals that when you read them in light of modern, sophisticated, progressive era, you're appalled. You really should be. The Germans, for example, in the very aftermath of the Normandy invasion of June in 1944, a French resistance fighter killed one German officer. They, in turn, killed 642 civilians, executed them from that village, a reprisal against a protected person. So in 1949, it's no wonder that the convention then grows to specifically outlaw that. It should, and it's perfectly appropriate. I could give you lots of other examples. Verdun, here's a good example of the way it's supposed to work in practice. The theory behind reprisals, for those who haven't thought about this lately, because after all, it's an easy rule. Why do I need to think about it? Everybody knows, so let me think about this easy rule. The British and French, in the context of Verdun, began misusing German prisoners of war to do things that were clearly prohibited, for work in appalling conditions. I mean, absolutely appalling conditions. Lots of ICRC correspondence home, facilitated by the International Committee of the Red Cross. I'm living on breadcrumbs and grass, while the persons who have captured me, the British and the French, are forcing me to work, 18-hour days in this back-breaking labor. So what do the Germans do? Specifically, what we would today call a reprisal. They took British prisoners of war. They started working them the same way. Those British prisoners write the same ICRC-facilitated correspondence home, gets into the British press, and voila, you have a change of policy. The British and the French say, we're going to stop using these prisoners of war. If you'll stop using ours, great. Everything is better. Those people are protected. That's the point of reprisals, is that it does serve as one vehicle for ratcheting up compliance with the laws and customs of war. Now, why then logically extend it in the 1977 protocols? This deterrence model argument was postulated, and I'll read to you from the ICRC conference report. I love this, and it's a classic understatement. The validity of reprisals as a deterrent measure, the conference did not share this view, period. So in the language of Article 77, the only people that you're actually protecting by extending this prohibition on reprisals, you've already protected all the people you care about in international armed conflicts. In the language of Article 77, the only additional class of people who are protected are those who are not otherwise qualified to more favorable treatment. Precisely the category of people that confront us today in this transnational struggle. This is also important against the backdrop of the Article 50 definitions, which we can talk about, and the Article 44 expansion of combatant categories. Critical question. If you're going to define the civilian population as everybody who's not a combatant in the dualist view of Article 50, what you're really saying is, as a matter of logic, reprisals can never be lawful. So if you accept that dualist view of Article 50, that anybody who's not a combatant by definition is always a civilian, civilians are always protected from reprisals, it's only logically consistent that the prohibition on reprisals be extended. The problem with that, of course, is that it's not the way the real world works, and I think today it's fair to say we recognize that there is a class of unprivileged combatants, unprivileged belligerents, who, in the language of Article 75, are not otherwise protected. They're there. They exist. And I think it's incumbent upon us to define the terms and conditions upon which it is rational and lawful to target them. So let me give you 3 reasons why I think it's necessary in just a few minutes to reopen this debate about reprisals. Of course, recognizing that this is what happens in the real world. President Clinton, there's an assassination attempt. The president orders, bombs to be dropped in Sudan against a Sudanese, quote, aspirin factory. Explain that in any other rational way other than that it's a reprisal, right? Later upheld by the federal courts applying the rubric of the laws and customs of war. An alien tort statute will not stand. It's not a tort in violation of the law. Well, why? And the point is, because there's no clear-cut law of reprisals, the federal court, even the federal court, has to simply avoid that question. And say, well, it's executive privilege, it's executive conduct of hostilities. I think it's incumbent upon us as the attorneys in this field to come up with more precise rules, to constrain, but also to guide policy, so that if in fact we can, I think this is one of the fundamental problems of our time, actually, and the ICRC would agree with this, is increasing compliance for the laws and customs of war by those who are otherwise outside its purview. They're not subject to state authority that cares about the laws and customs of war. It's a real fundamental problem. And reprisals is one way of getting at that, which we shouldn't be so cavalier just to throw aside. 3 reasons why I think we need to readdress this. Number 1, the blanket prohibition on reprisals, this normative bright-line rule, has forced us to shove everything back into the jus ad bellum framework. We approach all of these issues, whether it's a targeted killing or however, we've all shoved it back into, after 9/11, the jus ad bellum lawful right of self-defense framework. And that's very useful if we want to avoid the real problems. That doesn't tell you who can be targeted, under what circumstances. It doesn't address the geographic problem. It doesn't address the problem that Scott has posed of who's a lawful participant in that, what are the limitations on that, what are the temporal limitations, what are the geographic limitations, and more importantly, what it doesn't do is to serve as any kind of a useful technique for undercutting the core base of terrorism support. A clear-cut law of reprisals would allow us to say in public, as we would do under the Geneva Conventions themselves, or pre-Geneva Convention, you are violating the law. If you don't cease and desist from violating the law, this is what will happen. It would allow a clear-cut dialogue rather than simply allowing the propaganda that says, oh, you killed X number of civilians today. Because we would now have a legal framework which we could appropriately apply. Second point, and this is very subtle, but I wanted to raise it because I think it's very important in practice, and it's particularly important for U.S. policymakers. Any U.S. policymaker who wants to conduct hostilities on the territory of any state party to the International Criminal Court, which I would remind you includes Afghanistan, needs to be aware of the backdrop of the ICC elements of crimes. The ICC elements postulate in the overall general chapeau, and I'll read it to you. It's the general chapeau, paragraph 6. The requirement of unlawfulness found in the statute or in other parts of international law, in particular international humanitarian law, is generally not specified or restated in the elements of crimes. In other words, let me translate that for the students. Every single time you see an actus reus, you may not kill a civilian. Any actus reus in the ICC crimes, you always have to insert 2 sort of invisible ink words in there. You may not ever intentionally, you get that from Article 30, and unlawfully kill a civilian. So let me be clear about this. By not reassessing the law of reprisals, what we're really saying as practitioners is we are perfectly happy to allow the International Criminal Court and the ICC prosecutor to determine what is a lawful use of force in all circumstances. Because under the elements, a lawful use of force falls squarely into that unlawful exception. It is lawful under the established rubric of the laws and customs of war. Hence, you don't even get substantive jurisdiction, even if you've committed the actus reus. And therefore, as a practical point, by not reassessing the law of reprisals, we put our clients in danger of post hoc criminal critiques. And as a lawyer, I'm not comfortable in saying, oh, let's just sort of do it and see what happens. I like to have the certainty and the predictability of helping to shape the legal rules. Lastly, and I want to close with this as sort of the last thing I wanted to say, we can talk a lot about the targeting rules and the Article 44 constraints, the extent to which people are lawful combatants. But let's be honest. As a pragmatic reality of a world confronted by organized transnational actors, and I like Matt's characterization of the hierarchical, the top-down approach, or the diffuse approach. David Kilcullen has written a lot about this. It's a great piece of work. By not clearly addressing the law of reprisals, we have a regime that's not really well suited to address either. The law of reprisals allows us to have a flexible, pragmatic set of constraints that are applicable either way, to either type of threat, no matter where it surfaces, and it gives us some clear guidelines. I think this is one of the fundamental challenges of your era, and I say your students because over your career, this is one of the fundamental challenges you're going to have to address. To what extent does international law have gaps, particularly over transnational non-state actors, that we're willing to say, well, there is no law there. Protocol 1 certainly doesn't apply. As a positivist treaty matter, of course it doesn't apply. So the question is, how far does this extend as a matter of customary state practice? Answer, in light of the practice of states in the Vienna Convention on Law of Treaties rules in Article 31 and 32, very clearly the practice of states is that we are doing reprisals. We're just not calling them reprisals. So to the extent that we ignore this debate, what we're really saying is, for the core issue of our times, we're unwilling and unable to confront, as a matter of concrete legal terminology, the core issues. We're just going to keep avoiding them and keep pretending like, well, nobody's really quite sure of the rules, and therefore we're willing to accept the consequences of potential post hoc criminal accountability. Thank you.
Thanks, Mike. I think there is a consensus that there is a lack of clarity in some of the rules, and I want to pose all three of you a hypothetical to see if we can get more clarity. The intelligence community believes that there is a bomb maker in a particular country. I don't want to name a country, but it is not Yemen, it is not Afghanistan, but neither is it a country that we would consider favorable to our interests. The intelligence community believes that that bomb maker must be terminated. So the question that I pose to you is, as a matter of law, not policy, who makes the determination on whether that country is unable or unwilling to deal with the threat? Secondly, what if that bomb maker is an American citizen? And thirdly, what if the manner of execution or killing is a Predator or Global Hawk drone that is piloted by a CIA officer who is the trigger puller? Gentlemen? John, you want to start?
Is this when the Jeopardy music begins?
Yes, the clock is running, John.
Let me tell you how, in general, the U.S. government would address an issue like this. Now, just because that's the way the U.S. government would address it doesn't mean that it's not free from criticism, because I expect there would probably be lots of criticism. In general, the first issue is this a targetable person? And that gets to much of my talk. Is someone who's just making the bombs a combatant or not? Arguably, he's a civilian. Never been on the battlefield. He just sits in his house and makes these great bombs. The view of some human rights groups would be, no, he's not a combatant at all. He's a bad guy, but someone needs to go in and just arrest him and try him for his bad things. I think in general the view of the U.S. government would be that he is a combatant. I mean, it would, you want to have a lot of evidence that, he was making lots and lots of bombs, and that he was in fact, that the bombs that he was making were in fact resulting in the deaths of U.S. persons, but that one could in fact use force in self-defense. You really are defending Americans. You might be saving hundreds or thousands of lives even. So he would be a legitimate target. If the fact that he's an American, both international and domestic law in particular have said that really does not change the standard. If an American goes and is continuing to threaten us, and Scott, actually the law of war better on these things, but there are cases that say just because you're American, if you're fighting, doesn't mean that the United States can't use force against you. I think this gets complicated. I think probably constitutionally the Justice Department would say, because an American does have certain constitutional rights and would be entitled to greater due process, that one would have to really be sure this was the right guy and he was really making lots of bombs and that there was really no other way to go about doing it. But that one could then drop a Predator missile on top of this guy, and that would not be, while yes, it falls into what Mike says is a bright line prohibition, extrajudicial killing, because it's a killing of someone outside of any sort of judicial framework. I'm reasonably confident that this is the sort of thing that the Defense Department, the Justice Department, the CIA together would say would be permissible as an action in self-defense. I mean, in general, if you go all the way back to the Clinton administration, even before 9/11, the Clinton administration was launching T-lamps at members of Al-Qaeda in Afghanistan. As practicing lawyers, this gets into these difficult issues. Again, don't just sit in your classroom here, but think, if your director of Central Intelligence comes to you as the president and says, this guy is making lots of bombs, I'm absolutely certain of it, he has been responsible for the deaths of thousands of Americans, whoever it happens to be, the Pakistanis or Somalis, are unable and unwilling to do anything about it. Are you going to say, Mr. President, I realize this is a bad guy, but I cannot think of any possible legal theory under which we can do anything about it, so he's going to just have to sit there. It's a tough question, but I think the U.S. government would actually say he's a legitimate target and that one could use force in self-defense and take the criticism from groups who would say, and that's essentially the situation that we're in.
What about the CIA being the trigger point?
As far as whether they would have some sort of immunity or not?
Or combatant privilege?
Or combatant privilege? Difficult question. I think probably since they are not part of the armed forces of a state, they would not be perhaps protected combatants if someone actually found the person who was the pilot who was later vacationing in Germany or Paris. It might be difficult for that person to claim combatant privilege.
I think Pinella is saying no, we're not going to do that. Any other comments on this?
I want to add in.
Okay.
Go ahead, Eyal.
Yeah, I was thinking about how the Israeli court would respond to this question from the perspective of Israeli. We have the targeted killing judgment of President Barak from 2005. And I think what the court would say, first of all, the question of what law is applicable. Is it international humanitarian law? Is it human rights law? Is it Israeli constitutional law? Because this is, in the case if there was an Israeli citizen and Israeli operator. I think in all three possibilities, the court would ask the question, first of all, are there any if this is a person that is involved in dangerous activities, can he be considered taking part in hostilities? And the court has some guidelines for an answer. I don't have time to go into that. But the court admits that we have to go from case to case, and we need, instead of a normative guideline, make a procedural analysis based off, first of all, alternatives. Are there any alternatives to capture the person instead of killing, and using the local police to take it? Then the question would be, you may go ahead, but then you should be worried about ex post investigation, should be impartial investigation. And the court says, don't come to ask us. We will not give you death warrants.
A priori. Well, and just to be clear, because I want to spend a lot of time on other student questions, what we're really focusing on, the two ends of the extreme, just to be clear, is that law of direct participation. How far does that going to extend? Civilians are protected persons, and until such time as they're directly participating in hostilities. So now we've attenuated that more and more and more. And I think to pick up on the earlier comments, we're still in an agreement. I agree that the U.S. government would have an expansive view of that, not a universally shared expansive view, however. We would get lots of debate about that, particularly where there's a geographic shift. That bomb maker happens to live in Swaziland or some other place. It's very controversial. But the other side of it, which I think makes your question really interesting, is you see the dichotomy. To the extent that we want to apply the rubric of self-defense and the laws and customs of war to say, yes, of course, that is a person directly participating in hostilities, so therefore they are a lawful target. We then run into the real problem of creating a class of privileged combatant where there is none. We say, yes, CIA or to use your question, or whomever, is entitled to combatant immunity simply by virtue of the fact that we have done this under the rubric of the laws and customs of war. Now go back and try to squeeze that into the existing rubric of laws and customs of war. That's why it's a good exam question, because it really doesn't fit. Which leads me back to what I was going to say. If we had a clear law of reprisals, we'd be able to say, oh yeah, it's great if we can do this under the existing rubric of self-defense and the existing rules. But there's another alternative out there, which is to simply say, here's a clearly constrained baseline of reprisals that are subject to international debate and dialogue, and therefore, here's the key point, it doesn't matter who did the targeting, or pulled the trigger, did the killing.
Right.
Because we've acknowledged a priori that they're not within the existing confines of the law, and that's the whole beauty of that rubric.
Of course, and I want to open it up to questions, but the interesting, and I'll leave it as a rhetorical question, if the use of force in this type of situation is supported under our theory of the law, then does it make a difference whether it's Somalia, Saudi Arabia, or Durham, North Carolina? All right, let's open it up to any questions. Michael.
I'll defer to any student who wants to jump in, but if not, a quick question to my esteemed co-author, Professor Newton. This is about the dichotomy between reprisals and self-defense. The George W. Bush administration's preemption doctrine really wasn't new. It's basically the George Shultz doctrine developed under Ronald Reagan's administration. And having been at the State Department during some of those, I know that what was key to all those cases of these strikes was basically an indication that this was not a reprisal, this is not revenge killing, but rather that there was a determination that this was in response to one of a series of attacks, and that there was a great likelihood that the attacks would continue unless they were stopped, and that's what made it self-defense. Now my question is this. In self-defense, you have to have necessity, and you have to have proportionality.
Imminency.
Why don't those two terms encompass all the things that reprisal does in terms of the long list of things that you said were the necessary boundaries to keep this bottled up?
Yeah, the short answer is, and by the way, I thank you to Michael, because write that down, because I'm still thinking about this, and I want to answer all these questions in minutia in writing. My sense of it is, though, we do an imminency and proportionality analysis in the jus ad bellum framework, but we do it very quietly behind closed doors, and we don't talk about it, and we don't publicize it, and therefore, A, it's always going to be questioned. It's never going to be completely understood because there's no clearly defined framework by which we get agreement on that. But in doing it under that broad rubric, I think we lose a really important function, which is the ability to say publicly, you are violating the law in whatever you did, and stop, and let's have a dialogue in public. Here's what we will do in response to that. We can't have that debate. And I think in a fundamental way, what we end up doing, as long as we're stuck in the very broad jus ad bellum structure, is we end up with this cycle of violence without a clear understanding of the peripheral legal facts. You did this, we did this. You did this, we did this. You did this, you did this, we did this.
In Article 51, the last sentence says that you have to report to the Security Council, and that is your transparency. I wrote the report for Madeleine Albright when we attacked Iraq in response to the assassination attempt against the first President Bush during the Clinton administration. And the dog and pony show that we produced was extremely detailed.
I agree,
And-
but
and
we're
so that
talking to
can
the Security
happen.
Council there. We're not talking to the Kill Cullen supporter in Indonesia. That's our audience. Those are the people we want to deter. There's a legal framework of jumping through hoops, as you say, at the political level in the UN, but that's not our audience. I mean, it's helpful, of course, if we can persuade world opinion that we were right and use a legal metric. But our real audience are the people in the field that we're trying to deter, we're trying to address. And what I want to try to come up with is a framework. You know, we can give lots of examples where the debates in the Security Council and the debates in the General Assembly are hot and active and productive and many times coming out on our side and have no effect whatsoever on the ground. And I want to try to grapple with that other problem. What do we do about the perceptions and the realities on the ground, whether it's in Peshawar or wherever?
Questions?
Yeah, this is a question for Professor Benvenisti. So I understood you to be focusing on what is in this area largely asymmetric warfare between powerful states with advanced technology and then the non-state actors that we're talking about. And that one way to address this asymmetry, which is not addressed in the law as such, it envisions essentially symmetric states that make reciprocal agreements, is to, or at least the suggestion I thought you made was to then put on a more powerful technologically advanced state the asymmetric obligation of perhaps in the context of ongoing conflict, they have the obligation to act as an occupying power, so that instead of just respecting rights, they actually have to ensure rights. So my question is, what are the trade-offs involved in that, right? I mean, it's clear that the advantage is that there are going to be better protections for civilians, but then what does that mean for non-state combatants? Do they also end up with better protections and therefore make them more dangerous, more able to operate in that environment in a way that is more troublesome for the more technologically advanced state? So I'm just curious what possible sorts of trade-offs there might be. And then just perhaps more of a question of politics, which is how likely is it that there would be asymmetric obligations put on more powerful technologically advanced states in terms of thinking of a new way to do law of war or sort of placing new obligations to try to remedy what is a clear asymmetry?
Right. Well, I think that this is a very important point that you're making, of course, the most sensitive part. Clearly, by imposing heightened responsibility on the powerful side, it assumes maybe some would regard too much on the powerful side. But the point is that we tend to focus on the weaker, the unprivileged combatant of the weaker side, and their violations of the law that renders them subject to retaliation and reprisal, etc. What we less consider is the fact that by allowing more freedom with respect to unprivileged combatants, we expose the civilian population to more harm, more risks. I would say that this is maybe wrong in terms of policy. Look at the position now of the U.S. In Afghanistan. They want to reduce animosity within the population, and this is why General McChrystal is enforcing more restraints. So it makes political sense. It makes to increase the obligation on the powerful side, and And the point is simply that in terms of the ability of the law to to impose constraint on the powerful side in asymmetric warfare, where there's no reciprocity involved, both from its own perspective, because it has nothing to fear. There's no, in terms of if it violates the law, what the other side would do. The imposing strengthened, enhanced obligation on the powerful side would ensure not only the protection of the civilian population, but also would ensure its own interests in terms of combating terrorism. The idea is that the way to combat terrorism is not by killing the combatants, but by withdrawing the support the population has for that combat. And one way to do it, as what is practiced now in Afghanistan, is to treat the population better.
Okay, and one last comment on that. When you talk about downsides, I worry, Eyal, about restricting the use of air attacks and ground attacks to such a great extent, far beyond what Article 37 requires, that we establish a state practice that then creates a new and higher obligation on states like the United States. But David, talking about targeting, you need to target our panel and get up here. But join me in thanking this panel.
Virtual occupation.
Thank you for the great panel, and we are currently moving to our lunch break. We would ask for courtesy that our panelists be able to go first and get some nourishment, and then everyone else just proceed out to the loge area.